Welcome to Spotting the Issues, where we discuss business and legal issues impacting entrepreneurs and growing companies. I'm Emily Campbell. I'm a real estate investor, an internet entrepreneur, and managing member of the Campbell firm, PLLC, a general practice law firm based in Manhattan. I have guest lectured at Columbia University's Lang Center for Entrepreneurship, Parsons School of Design, and the School for Visual Arts, and many micro-entrepreneur programs, and have been involved in business plan competitions at Columbia University's Lang Center for Entrepreneurship, Baruch's Field Center for Entrepreneurship, and Fordham University. I am an adjunct professor of law at New York Law School, where I teach drafting contracts and advising entrepreneurs. Today's discussion is S Corporations versus LLCs. Many entrepreneurs are trying to determine whether to set up an S Corporation or an LLC. We're going to set aside the C Corporation discussion for another seminar, but we're going to focus today on S Corporations versus LLCs, which are typical choices for small businesses. It's important to understand and to make an appropriate decision before you form your entity in order to make sure that you choose the right entity, because setting up an entity that is not the right form for you could result in more costly reincorporation at a later point. S corporations and LLCs are not identical, even though many accountants think they're identical for a number of reasons, including the fact that these are both pass-through type of entities, meaning the income or losses flows directly on to the individual shareholders' tax returns. Now, this is a tax advantageous position for both of these kinds of companies, but they have limitations, each of them. And the S Corporation has more limitations than the LLC, and we'll talk about those two distinctions so that you can see which corporation structure would be more appropriate for your business. Of course, you'll be consulting with your own accountant and attorney to determine your specific needs, but we're going to talk about these in generalities. The S Corporation is limited to 100 shareholders. The IRS increased this designation. The federal government passed laws. It used to be a 75 shareholder limit, but it was increased to 100 shareholders. Now, this may sound like a lot of shareholders, but if you are trying to raise capital from other people or have multiple people who may want to offer equity to in return for compensation for doing particular work or so forth, this 100 limitation may prove difficult for you. The LLC does not have any such distinction. They do not have any limitation on the number or type of shareholders. Now, the S Corporation, in addition to having the 100 maximum, is also limited by the fact that there are types of shareholders that you cannot have in an S Corporation. You cannot have anyone who is not a U.S. citizen or a green card holder. Now, this is potentially problematic because you may want to do business with foreign nationals, people who are from other countries, and this could be somewhat problematic. Now, you're also limited by not being able to have entities take shares in your S Corporation, with some exceptions, which we won't get into in this discussion. But in general, an S Corporation has to have human beings, not other corporations or other LLCs, as the shareholder. And so, if, for example, if you were a fashion company and you were trying to make a decision about whether you were going to have your overseas manufacturer be a partner in your business and own shares in your business, you would not be able to do that in an S Corporation. In contrast, the LLC has not only no restrictions on the number of shareholders, but also no restrictions on the type of shareholders. So shareholders can be individuals, they can be corporations, LLCs, other types of entities, and they can exist anywhere in the world. They're not limited by geography. Now, another really important distinction that's very important for you to consider when you're determining whether you're going to set up an S Corporation or an LLC is whether you are going to have any kind of preferences that you want to offer shareholders. So in an S Corporation, you're limited to a single class of shares. In a regular corporation, a C Corporation, you can have multiple classes of shares. The LLC is more like the C Corporation in this regard. There are no limitations to different preferences that you can offer, and by preference we mean a liquidation type of preference usually, where someone will have this opportunity to offer if there is a liquidation event, either a sale of the company or if unfortunately the business is failing and has to liquidate, the opportunity to have people who have these preferences be paid first out of the available funds after creditors have been paid. So this is an important distinction because in the S Corporation you cannot offer any preferences. You may have differences in voting rights in terms of shares, but there's only one class of stock. In the LLC, you can set up any number of different preferences, any different voting rights, any different special arrangements that you want to make. And you can even, which is an extra plus about the LLC, make a distinction between how much profit or loss that you want to allocate to any particular shares. With the S Corporation, it's typically a one-for-one kind of a relationship. So this is an important thing to understand. I would footnote that the LLC does not call the equity pieces shares or stock. They're referred to as membership units, but but functionally they are very, very similar. And so for the purposes of this discussion, we're going to be treating them identically. Now, another really important piece of the puzzle here is that in the S Corporation, the owners, the people who are the equity holders, are going to have to pay themselves minimum salaries, essentially, what is a reasonable compensation. And by minimum salary, I don't literally mean a bare minimum. It has to be a reasonable compensation. The IRS has certain guidelines about this, but this is going to be true even if you're losing money. And this could be potentially problematic because of the payroll taxes and other things that are associated with this type of situation. The LLC does not have that. The LLC is strictly you taking distributions. There's draws or capital contributions if you have to put money into the business, draws coming out. You can set up payments on a regular basis for people, but there's no requirement that you do that. So that you don't pay payroll taxes on an ongoing basis this way. So this is an important thing to think about also in terms of cash flow. You see with sometimes businesses that have good cash flow and consistent cash flow, this makes sense. If you have a very seasonal business, this may not make sense to you in terms of having to pay this regular cash payment. In New York, the LLC has one strong disadvantage, and that is the extra charges associated with what they call the publication requirement. This is an important point in your terms of your budgeting because the publication requirement in New York County will jack up the cost of forming the entity and getting it going and being in good standing in New York about $2,000. So that's something to consider, but when you're looking at over the long term and the tax preparation expenses that you might be spending with your accountant with the S Corporation versus the publication charges that are filled out, done at the very outset, and then just simply having K1s, which are partnership type of returns, which is a typical designation when you have more than one partner. If you only have a single member LLC, it strictly goes on to Schedule Cs, very, very simple pass-through. So these considerations have to be made prior to forming the entity. Now, many people think when it's time to form the entity, I can go on to any kind of online provider and I can fill it out myself, or I can go on to the Department of State website for any particular state in the United States and I can do it myself. It's really the decision at the beginning, which should be made in conjunction with your accountant, your attorney, and any of the other principals involved in the business to determine which of the forms makes the most sense. The paperwork associated with forming it is relatively nominal. It's the decision making and all of that discussion that goes in, and that's the advantage of hiring a professional to do the work with you to make sure that you filed the right type of entity formation so that you can be up and running and be set and not have to change your entity structure at another time. Now, the material provided, we hope you have enjoyed this segment of Spot the Issues. This has been presented by the Campbell Firm PLLC, a business-oriented law firm located here in New York City. The program may constitute attorney advertising under New York law and other laws. Prior results do not guarantee any future outcomes. Material provided on Spot the Issues is for educational and informational purposes only. You should consult with your own attorney and other business professionals concerning your specific needs. Should you want to continue the dialogue or speak to us about legal representation, log on to our website at www.campbellfirm.com. This segment, called S Corporations versus LLCs, is the sole property of the Campbell Firm PLLC, copyright 2012, all rights reserved. Thank you for joining us.